This film is a project of the Leonore Annenberg Institute for Civics in partnership with the Annenberg Foundation Trust at Sunnylands. Citizenship is every person's highest calling.
The attacks on the U.S. on September 11th shocked the nation.
An extraordinarily well-planned terrorist attack on both Washington and New York has taken place this morning. The trade centers here in New York, the two World Trade Center towers have collapsed.
It was not the sort of thing that we thought could happen to us. The American homeland seemed very secure. So it was psychologically quite devastating to have this kind of harm inflicted.
It was a terrible attack on us, 3,000 people killed.
When the plane was flown into the Pentagon, it was the heart of the United States military that had been attacked, physically, right there in Washington. And if that could happen, then what was next?
After September 11th, 2001, the nation was afraid of another attack. And history shows that when the nation is at war and feeling as though its security is at risk, when people are afraid, the balance between national security and rights guaranteed by the Constitution can falter.
The Constitution is at its most vulnerable when we're in a crisis.
Associate Justice of the United States Supreme Court, Anthony Kennedy.
We have to remember that the law and the Constitution are for hard times as well as good times. Our liberties are most in danger in times of crisis.
The Constitution applies in wartime as in peacetime.
Associate Justice of the United States Supreme Court, Stephen Breyer.
And after all, that's what we're fighting for the constitutional values that Constitution embodies.
Those values include fundamental rights and protections guaranteed by the Constitution. But who guarantees them, especially during a time of war? After the attacks of 9/11, as America fought two wars abroad, all three branches of the federal government, the executive, the legislative, and the judiciary, fought over the balance between national security and civil liberties. The fight escalated over 4 Supreme Court cases as the court tried to balance the president's duty to protect the nation with constitutional protections of fundamental rights.
When the political branches don't necessarily protect people's rights at time of war, the duty falls to the courts, and if they don't do it, no one will.
And at the heart of it all was the right of habeas corpus. Habeas corpus isn't a magic spell.
It almost sounds like a Harry Potter incantation.
But if you're locked up, these are words you want to hear. If you're in prison, you have the right to go to court and force the government to explain why it's holding you. That right is called habeas corpus, which is Latin for
have the body or produce the body.
It's from an English legal history, and it literally means a judge's order to bring the body to the court. It is a very fundamental protection against executive punishment without due process.
Check this out. The Bill of Rights, freedom of speech and religion, right to an attorney, freedom from cruel and unusual punishment. These are all amendments, remember? They came after the Constitution was originally written. But look at habeas corpus.
The habeas right is spelled out in Article 1, Section 9, which is part of the original Constitution. The other thing you might say about placing the habeas right in the initial Constitution rather than the Bill of Rights is that it's really more about the structure of government. So the point of habeas is to reinforce the separation of powers by making sure that all three branches cooperate in order to deny an individual liberty.
This is how important habeas corpus is. Even after the Constitution was ratified, the framers wanted to spell out in writing that the habeas right should be protected by the judiciary. So the very first law passed by the very first Congress gave the courts the power to hear habeas petitions.
If we didn't have the right of habeas corpus, this country would be like a country in which you could have secret detentions, in which people would disappear. you wouldn't necessarily know why. You wouldn't know where they'd gone. Maybe you would never see them again.
There are other countries in the world today where people can spend weeks or years in custody without ever getting the chance to challenge their imprisonment. There's no habeas corpus, so there's no law that lets them check the power of the king or president who put them there.
There are countries like that, but we don't consider them democracies committed to the rule of law.
The American founders said we need to check the abuse of power by dividing power among the three branches. And the simplest way to think about it as almost like a series of three light switches. And in order to deprive someone of their rights, our founders said, all three branches have to agree.
The right of habeas corpus basically says we don't trust any single branch of the government, and especially not the executive. So the writ of habeas corpus is a fundamental protection against abuse of executive power. Because without it, the executive could simply go around and round up its enemies without any accountability, lock them away forever, and no one would even know.
Especially when that executive was a king. Habeas corpus goes back to at least the Magna Carta, and while the king's power was limited on British soil, colonists in America were routinely locked up by the king's military with no hearing or trial.
It was an enormous danger. And so to them, it was not just an individual liberty. It was an essential part of limiting the power of the executive branch in a way that would prevent it from engaging in certain types of abuses.
President, you can't just imprison me on your say-so. You've got to come into court and explain why you're doing it.
So the executive can lock you up, but you have the right of habeas corpus, so you can challenge the executive in court. And Congress has the power to suspend habeas corpus right here in Article 1, Section 9, but only in cases of rebellion or invasion. That's called the suspension clause, and it's hard to use because habeas corpus is such an important right. Because habeas corpus can only be suspended during times of rebellion or invasion, it has been at the center of more than one wartime crisis. At the start of the Civil War, Washington, D.C. was surrounded by Confederate sympathizers before Union troops were in position to protect the capital city. Congress was out of session at the time, so President Lincoln suspended habeas corpus and arrested many of the Southern sympathizers, he said, to save the nation's capital.
This was the Civil War, and it was a rebellion.
Supreme Court Chief Justice Roger Taney ruled that the president violated the Constitution. He argued that the suspension clause is in Article 1, which spells out the powers of Congress, so habeas can only be suspended by an act of Congress and not the president. Taney said the president had to let the prisoners appear in court. President Lincoln ignored the Chief Justice. If the Capitol fell, he argued, the nation would come to an end.
And he said, what would you have me do? Would you have me let the entire Union dissolve, all of the laws that we love gone, just to respect this one law?
Lincoln saved the nation, and he did so maybe in part by violating the Constitution and suspending habeas corpus.
After the attack at Pearl Harbor drew the United States into World War II, another president sought to suspend habeas corpus, afraid of a Japanese attack on the West Coast. President Franklin Delano Roosevelt ordered 120,000 people of Japanese descent, most of them American citizens, rounded up and put in internment camps for fear they might be disloyal. There were no hearings, no chance to appeal being locked up because of their race.
A few brave individuals challenged that scheme, and their cases went to the Supreme Court.
The U.S. Supreme Court said that this was something that the federal government was entitled to do, that this wasn't a violation of the command in the Constitution that people be treated equally.
Because it was wartime, the court said it was okay.
It was a sad day for the court.
It's probably, the greatest stain on our constitutional fabric.
We have thousands of people, and yet they don't get protection. Was it because of war? Yes. Does that make the decision right? No. But war is difficult because it blurs the vision.
Justices have given the president and the generals the benefit of the doubt during times of war because the president gets briefings about national security, updates on battles and locations of the enemy. The justices don't. The court has never said that the United States shouldn't defend itself. But since the internment cases, times have changed. The court has learned that the executive branch misled it during the war, and the court has pushed the president to protect civil liberties while also protecting the nation.
Well, what I think has happened over time is that the court has become open to the possibility of more sophisticated solutions, legal solutions that give the president authority to do quite a lot, but do not allow the president as commander-in-chief to run roughshod over civil rights that are guaranteed by the Constitution.
And that's what happened after 9/11. 4 cases over 4 years that came to be known as the Guantanamo cases. The court and the president and even Congress fought over the balance between national security and civil liberties during the war on terror.
Tonight we are a country awakened to danger and called to defend freedom. Our grief has turned to anger, and anger to resolution. Whether we bring our enemies to justice or bring justice to our enemies, justice will be done.
After the terrorist attacks of September 11, 2001, President George W. Bush announced a general war on terror. This was not a conventional war with soldiers representing nations on a battlefield. The president was going to go after suspected terrorists all over the world, and Congress supported him.
Congress passed a resolution authorizing the use of military force to basically attack, hunt down, kill, or capture those responsible.
But there was a problem.
It's not always clear whether the person that you're dealing with is a terrorist or not.
How would you know whether you had the right person or the wrong person? This is not somebody wearing a uniform who's in the army of an enemy country.
In most cases in our judicial system, it's not enough to say we think this person is dangerous and might do something bad in the future. You have to have actual proof that they have broken the law before you can detain them.
The executive branch announced it was going to label war on terror prisoners enemy combatants and limit their rights. No habeas corpus, no judiciary. The president wanted to hold enemy combatants as long as he thought it was necessary and didn't want them to be able to challenge his authority in court.
If I determine that it is in the national security interest of our great land to try by military commission those who make war in America, then we will do so.
The Bush administration took the position that they could label someone an enemy combatant, and by doing so, deprive them of the most foundational rights, including the writ of habeas corpus.
The first 2 Guantanamo cases were decided on the same day. In Hamdi versus Rumsfeld, Yasser Hamdi was a U.S. citizen arrested in Afghanistan and held without charges in the United States. He wasn't allowed to have a lawyer. His dad filed a habeas corpus petition to get him into court, where the Constitution gives him due process rights.
In order for an individual to have a meaningful opportunity to try to demonstrate innocence, you'd need a bunch of things. You would need someone who's not committed to either side, like a federal judge. You'd need the government to tell them, here's why we think you're a terrorist. You would need to give them some opportunity to rebut those charges. They might need to call witnesses, and a lawyer would be helpful.
The government argued that labeling Hamdi an enemy combatant was enough to hold him and limit his due process rights during wartime.
Here, the government is saying the process that is due is very minimal.
The Supreme Court ruled in favor of Yasser Hamdi. A U.S. citizen, even one labeled an enemy combatant, is entitled to due process guaranteed by the Constitution. The president had to let him have his day in court. Justice Sandra Day O'Connor wrote that
the state of war is not a blank check for the executive. The president can't just use a military necessity to justify whatever measure he sees fit. That there has to be a system of checks and balances over those assertions by the president.
In case number 2, Rasool versus Bush, Shafiq Rasool was not a U.S. citizen and he was not being held on U.S. soil. But here, in Guantanamo Bay Prison, Cuba.
Well, Guantanamo is technically part of the sovereign territory of Cuba. It's a U.S. naval base. It's on the island of Cuba.
What we know from the people who were inside the administration is the reason they chose Guantanamo was to precisely prevent the federal courts from having habeas corpus jurisdiction on the theory that habeas corpus jurisdiction for the federal courts only reaches as far as American territory.
One military lawyer said Guantanamo Bay was the legal equivalent of outer space. The president authorized the military to hold enemy combatants in Guantanamo indefinitely, beyond the reach of civilian courts.
The government said, we can suspend the right of habeas corpus at Guantanamo Bay because Guantanamo is not American soil.
The question was, you have this non-American citizen who's being held not in the United States. What right would that person have to habeas review?
Rasul argued that the U.S. controlled everything about Guantanamo, so it had to follow the habeas laws of the United States.
It's under complete American control. It's got a McDonald's. It's got a very nice gift shop. In all practical terms, Guantanamo is effectively part of the United States.
The Supreme Court agreed and ruled that Guantanamo is within the jurisdiction of the United States, so the president can't issue an order that breaks the law. Remember, the habeas laws go all the way back to 1789, and they don't say habeas is limited to territory inside the U.S., so Rasul gets to have his day in court.
The court says the habeas statute has no territorial limit. The habeas statute, by its terms, gives this right to anyone who says that they have been detained in violation of the laws, Constitution, or Treaty of the United States.
But the political branches didn't back down. After Rasul, Congress joined the president and passed a new law saying enemy combatants could not be tried in federal courts, even the Supreme Court, even the case it was already scheduled to hear. Case number 3, Hamdan versus Rumsfeld.
Hamdan is Osama bin Laden's driver. And the reason his case is important, the question in his case, is not really so much about who he is or what he's done. The question is, who can try him?
To protect national security, the president insisted he had the power to create military commissions that could try enemy combatants in secret with fewer rights.
What President Bush said is, I get to set up the process, I get to enforce it, and I get to rule on whether or not it's constitutional, and the federal court should have no business reviewing what I'm doing.
Neil Katyal was the lawyer who took Salim Hamdan's case to the Supreme Court.
So the case was about that simple idea that one man say-so, no matter how wise he is not enough in the American system to change the ground rules and deprive people of their most basic rights.
This time, the court didn't back down. It said it could hear the case. Then it said that the president's military commissions were a violation of the separation of powers because they were doing things beyond what Congress said they could. Worst of all for the president, the court ruled that his military commissions did not meet the standards of the Uniform Code of Military Justice and even violated international law. It was a major setback for a president during wartime.
The U.S. Supreme Court said that the military trial system that President Bush set up at Guantanamo Bay violated the Constitution's guarantee of separation of powers.
The majority opinion was written by Justice John Paul Stevens. Justice Stevens wrote that the prisoners had the right to see the evidence against them, they had to be allowed to attend their own trials, and appeals had to be heard outside of the executive branch. The court reminded the president that the president has to obey the law.
They struck down the first set of military commissions that President Bush set up to prosecute these people for violations of the law of war and said, you've got to go back to the drawing board and come up with procedures and tribunals that will protect the rights that our law guarantees.
For the president and his supporters in Congress, this was the last straw.
To win the war on terror, we must be able to detain, question, and when appropriate, prosecute terrorists captured here in America and on the battlefields around the world.
Congress said, okay, under the statute that we had in place, the court has determined both the citizen and the non-citizen in Guantanamo get habeas review. But Congress decided we don't want that to be the case, so we'll change the statute.
Congress went back to the drawing board and passed the Military Commissions Act of 2006 as a direct response to the court's Hamdan decision. This time, Congress wrote a law that denied enemy combatants habeas rights in any federal court in all cases without exception.
Scholars and news outlets called the case of Boumediene versus Bush one of the most important wartime decisions of the last 50 years.
This was a case brought by another group of detainees at Guantanamo Bay, including Lakhdar Boumediene, arguing that they were being held unlawfully.
His claim was the new statute that said that people at Guantanamo don't get habeas is unconstitutional.
These cases have all led to this moment. In each one, the court has saved the separation of powers and determined that prisoners will have their day in court. First, the court ruled that the president has to give a U.S. citizen his constitutional due process rights. Then it ruled that the president has to give a non-U.S. citizen held in Guantanamo Bay his habeas corpus rights. In Hamdan, the court ruled in favor of habeas corpus and that the president's military commissions violated military justice and international law.
And the question now is, do they have a constitutional right to habeas corpus?
And finally, in Boumediene, the court has to decide whether Congress and the president can write a new law denying detainees their habeas corpus rights, or is habeas corpus a constitutional guarantee, even for enemy combatants who are not U.S. citizens held at Guantanamo Bay?
And there the court says yes. Yes, there is a constitutional right. The procedures that the executive branch and Congress have set up are not adequate. So these people must be given the right to petition for habeas corpus.
If you are even a non-U.S. citizen being detained at Guantanamo Bay, you do have the right of habeas corpus, the right to at least come in and say, I didn't do it.
This time, the court put its foot down. Writing for a 5-4 majority, Justice Anthony Kennedy told the president and Congress that they can't use poor substitutes for this fundamental right. Justice Kennedy wrote that the laws and Constitution are designed to survive and remain in force in extraordinary times, even the war on terror. Over half a century after the Japanese internment, this time, the court demanded a balance between national security and civil liberties. But the balance for each of these men came slowly. Each man spent years in prison only to see his charges dropped by the government or overturned by a judge that heard their cases because of the right of habeas corpus.
In the Guantanamo cases, the court has more or less approached this step by step. It said the people in Guantanamo do have a right to go into court. And it's trying throughout to say the president does have authority to deal with a real crisis, but he has to be careful how he exercises it.
The law must insist that the law must always be obeyed. The consequence of the fear is that you may tend to forget your responsibility to protect your constitutional heritage. We have a compact over time. We have a compact with the founders, those who've made this nation, and we have a contract with future generations to keep our freedom and to remember the principles on which the law is based and to be faithful to them.